All right, we're on page 6 of the 1 to 4 family residential contract. And you remember uh, on the page before, we talked about the seller's usual and expenses that the seller pays. This is the expenses that are paid customarily by the buyer. And then it goes, unless if any expense exceeds an amount expressly stated in the contract for such expenses to be paid by a party, that party can terminate the contract unless the other party agrees to pay such expenses. Um, that doesn't come up much, but because that's all disclosed ahead of time. All right, prorations. Just so you can explain this to your buyers in the event that they don't know, the taxes for the current year, interest, maintenance fees, HOA assessments, all of that will be prorated through the closing date, which means that your seller is responsible for, say, the HOA dues from January to July 15th, and the buyer will be responsible for July 15th to the end of the year. That's like property tax, that sort of thing. So that's all going to be taken care of at closing. It'll be on the closing disclosure. It's not any additional money that the seller or the buyer will have to come up with at the time. Casualty loss, that's if the property is damaged or destroyed after the contract is executed on the property. The seller will restore the property to its previous condition as soon as possible, but in any event by the closing date, if he fails to, the seller can terminate and the earnest money will be refunded. Now, in the real world, like if a hailstorm comes through and takes out a roof of a house that is under contract, then the seller will go ahead and file an insurance claim, and hopefully that insurance company can settle that claim and then the roof get repaired or replaced before closing. If that doesn't happen, timely enough, then you may have to delay closing. Sometimes it says in here that if permitted by the seller's insurance carrier, the buyer can receive credit from the seller at closing in the amount of the deductible, and then the insurance carrier will assign that that insurance coverage to the buyer. Sometimes insurance companies don't want to do that. They want to see a roof on that house before closing. So you just have to kind of work through that issue if that's what happens. Default. If buyer fails to comply with the contract, buyer will be in default. If seller fails to comply, then the seller will be in default. Here are the remedies. Enforce specific performance, seek such other relief as may be provided by law. In other words, one party can sue the other party to, that buyer wants to buy that house and that seller changes their mind, that buyer can sue that seller and the court can make them sell that house, enforce specific performance, okay? Or seek other relief that may be provided by law, which could be damages. It could be maybe the buyer had already sold their house, now they don't have a place to live, and they're going to incur all this temporary housing expense and all that kind of stuff, where the buyer can sue the seller for other relief as may be provided by law, okay? Or terminate the contract and receive the earnest money as liquidated damages. Or if it was a buyer, terminate the contract and receive the earnest money refund of theirs, and be done. And that would release both parties from the contract. You can't do both. You can't terminate, get the earnest money, and sue. It's an either or situation. Okay? Mediations, policy of the state of Texas to encourage resolution by mediation. And that's just the way it is. Our attorney's fees, basically what this is seller pays. Loser pays. Loser pays, whoever loses ends up paying attorney's fees and all costs and all that stuff. Escrow. This is defining the escrows, the escrow agent, the escrow company, the title company's role in the transaction. They're not a party to the contract. They don't have liability for performance or non-performance of either party. They don't have liability for interest on the earnest money. They don't have liability for loss of any earnest money. They're just a disinterested third party that just is making the transaction work, right? Expenses at closing, the earnest money will be applied first to any cash down payment. So if there's a $4,000 earnest money check at the title company, the down payment is $20,000. That $4,000 will be applied to that $20,000 first, okay, and then it'll be applied to business buyer's expenses or anything like that, okay. Demand. For some reason, the buyer and seller get crossways, or the buyer decides to terminate the contract. If the buyer decides to terminate the contract and maybe it's during the option period, and they have every right to do that. Okay, they have a 10-day option period. They have every right to terminate the contract for any reason during those 10 days, unrestricted right. So, but what if it makes the seller mad? Okay, so the buyer will do a buyer termination of contract, and then they'll do a release of earnest money. And they'll send both of those documents to the seller and to the title company. Okay? So this is in this situation, upon termination of contract, either party or the escrow agent may send a release of earnest money to each party. The party shall execute the counterparts of the release. Okay? So that's, I'm giving you a scenario. So, but if either party fails to execute the release, then either party can make a written demand to the escrow agent for the earnest money. In my example, if the buyer terminates the contract during the option period and it makes the seller mad, or maybe it's during the number of days on the third party financing addendum, maybe they had 21 days, and on day 20, they figure out that they can't get the loan and they terminate, and that makes the seller mad. So the seller can also execute a counterpart of the release. They can generate their own release with the earnest money coming to them and deliver that one to the escrow agent. Okay, so then it goes back to law. It goes back to contract law and what the contract says. If the buyer is perfectly within their rights provided by the contract to terminate the contract and get their earnest money back, then it goes to damages. Okay, now we're going to skip down here, even though it's on the next page. Then it goes to damages because it says if any party who wrongfully fails or refuses to sign a release acceptable to the escrow agent, to the title company, within 7 days of receiving the request, they could be liable to the other party for damages, earnest money, reasonable attorney fees, and all costs of suit. So if the buyer has every right to terminate the contract according to the contract and get their earnest money back, and the seller refuses to sign it, the seller can pout for 7 days. That's what I tell my seller. Okay, you can be mad, and you can be mad for 7 days, and then we read this paragraph, and then that usually encourages them to go ahead and sign it. Okay, and that's just the way it is. I mean, that's just the way the contract's written. However, if it is kind of ambiguous, then sometimes you have to get legal advice and that kind of stuff, and that's another conversation for another class. Okay, but anyway, that's what this demand and how it parlays into this paragraph on damages. Okay, got it. And that would be page 6.